Thank you, everyone. I am calling to order the February 8th meeting of the Town of Scarborough Zoning Board of Appeals. Thank you, everyone, for attending. If we could first start with the Pledge of Allegiance. Before we'd all rise. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. As everyone knows, this is a public meeting, is being broadcast and recorded. Everything said here will be recorded in the minutes, and we will review the minutes of this meeting next at the March meeting. Doreen will now call the roll, if she would.
Michelle Stevenson,
Here.
Christine Snow,
Here.
David Bork,
Here.
Peter Freilinger,
Here.
and Kyle Noonan.
Here. And Kyle Noonan, you're an alternate normally, but we need you today for quorum purposes. So you will be elevated to a voting member for the purposes of today's meeting. We have the next item is the approval of the minutes. Have the members of the board had a chance to review? I'm seeing nods. Yes. Are there any corrections required or any comments? None. Then if I may have a motion to approve the minutes. Nope. Mr. Bork.
So moved.
Thank you. A second.
Second.
Thank you. And all those, we'll do this just by a show of hands. All those in favor? That's a unanimous vote for the approval of minutes. Thank you very much. We have two items on today's agenda. The appeal number 2742, administrative appeal by the law offices, of David Laurie on behalf of State Manufactured Homes, and a shoreline setback determination by Michael Morris of Archipelago on behalf of PMG Properties LLC, 446 Black Point Road. If we can, we're going to switch the order of those two. As in discussion with my fellow members here, we think that there's expeditious reasons to consider the shoreline variance first. So if we can start with that. Do we have a representative for the shoreline variance? And thank you very much, Brian. If you could join us, that'd be great.
Good evening. My name's Mike Morris from Archipelago, an interdisciplinary firm in Portland. I'm here on behalf of my clients, PMG Properties LLC. And first, I'd like to thank the board for reversing the order here tonight. Appreciate that very much. I should be able to wrap this up within about an hour and a half to an hour and 45 minutes. Hopefully that's all right. I'll make it quick. This is an application that, or it's not really an application, it's a determination request of the Board of Appeals. The situation is that we have a non-conforming structure located at 446 Black Point Road here in Scarborough. It's non-conforming primarily because it is located too close to the shoreline of a wetland, or the upland edge of a wetland associated with Massacre Pond, or a portion of Massacre Pond. The ordinance allows for, let me back up. The landowner, PMG Properties LLC, would like to remove the structure and replace the structure with something that's more modern and in better condition, obviously, than an older structure. The ordinance allows for the removal and reconstruction of a non-conforming structure in the shoreland zone, provided that the new structure is relocated, or the footprint of the existing structure, rather, is relocated to meet the shoreline setback to the greatest practical extent. And that the ordinance in Scarborough assigns that authority to the Board of Appeals. It's based on 6 specific criteria in the ordinance, and I'm just going to breeze through them very quickly. It's based on the size of the lot, the slope of the land, the potential for soil erosion, location of other structures on the property and on adjacent properties, the location of a septic system or other on-site soils suitable for septic systems. This property, by the way, is served by public sewer. And number 6, the type and amount of vegetation to be removed to accomplish the relocation. It's limited to those items only. I'm just going to discuss the first one, the size of the lot and the issues surrounding that. The size of the lot is it's a relatively modest lot, around a half an acre in size. It's encumbered by several different setback requirements. The side lot line setback of 15 feet in this particular zone, a road setback of 40 feet, and of course, a shoreline or wetland setback distance of 75 feet. If you'll take a look at the plans that were provided in the application, particularly the existing conditions plan, you quickly realize that there really isn't a whole lot of opportunity to move the current structure back a whole lot. In fact, the proposed relocation moves the structure footprint from 34.22 feet, I believe it is, to back to 40 feet and 1 inch away from the wetland at its closest point. And that is the maximum. We can push the structure back from the upland edge of the wetland, namely due to the 40-foot road setback. So we've maximized it, and that really is the limit. The other criteria, the other 5 of the 6 criteria that I kind of discussed very briefly a few minutes ago, really are not limiting factors. It's solely the size of the lot and the various corresponding setback requirements. So based on that, we would just request that a determination or agreement from the Board of Appeals, or a determination that the relocated setback to meet the shoreline setback to the greatest practical extent is as proposed. Happy to answer any questions.
Any questions from other members of the board? I have no questions either. What I would ask you, Mr. Morse, is just for the purposes of the record, could you read in for the record your assertion of the facts for each of the 6 criteria for the setback?
Absolutely, I'd be happy to. So the 6 criteria, starting with the first, the size of the lot. In the material that I've already provided to the town, I'll read through it very quickly. Considering the multiple minimum setback restrictions affecting this lot, including a 40-foot road setback, 15-foot sideline setbacks, and the 75-foot shoreline setback, there is very limited area available for the structure footprint to be relocated. In the attached site plan that we provided in the documents, we propose to relocate the structure in a westerly direction closer to the road, but still in conformance with a 40-foot road setback. This improves conformity with the shoreline setback, moving the structure approximately 6 feet further back from the wetland. The 40-foot road setback restricts structure relocation further from the wetland. A driveway turnaround, and parking area serving the lot is located within the 40-foot road setback area as well, and also restricts the relocation of the structure further from the wetland. For number 2, slope of the land. Excuse me, please. The slope of the land of the lot that is subject to this proposal is not prohibitive to construction and does not interfere with the structure relocation as proposed. The structure is currently constructed on the highest point of the land with a slope maintaining its elevation towards the road and slightly receding towards the wetland. Number 3, potential for soil erosion. There are no unique soil conditions or other soil features such that the relocation of the structure footprint would create risk of soil erosion from the lot. Number 4, location of other structures on the property and on adjacent properties. There are no other structures that are located on the property that would affect the proposed relocation. There are structures located on the adjacent properties to the north and south. However, the locations of those structures are immaterial to the proposed structure footprint relocation. Those structures do not limit footprint relocation on the subject lot. Number 5, location of septic and other on-site soils suitable for septic systems. Property is currently served by public sewer. The sewer connection does not inhibit the proposed structure relocation. And finally, number 6, the type and amount of vegetation to be removed to accomplish the relocation. Vegetation removal does not impede structure footprint relocation under the town ordinance. The area where the structure is proposed to be relocated consists of grass lawn and landscaping vegetation. The existing location from where the structure will be relocated will be replanted with grass vegetation as specified in the ordinance.
Thank you, Mr. Morse. Appreciate it.
Very welcome.
Before you step down, any comments or any questions from staff? Yeah, no, great. Okay, terrific.
Thank you.
With that, then, are there any members of the public that are here to speak on this matter? And have we had any comment from the public come in, email or phone calls or anything? I see that as a no from Doreen and a no from Brian. So with that, I will close the public hearing for this matter. And we'll go through the findings here. Are there any questions from my colleagues on the board here at this point? Gotcha. Then we will go through. Do we concur with the relocation criteria number 1, or the size of the lot, and that the appellant or the applicant has met the requirements to justify the size of the lot? Mr. Bork, could you start us off?
Sure. Really, this is the only issue here. The other 5 are minor and really insignificant, as the applicant has pointed out. The only feasible alternative here is to move it all the way up to the 40-foot front setback. They cannot go any further than that, so that satisfies the maximum compliance, to the shoreline zoning restriction.
Great. Any other comments on that from other members? Not seeing any. Terrific. And I would concur with Mr. Bork. The other 5 items are really not particularly material, but maybe Ms. Snow, if you could just speak to those 5 really quickly and say if you see anything that pops out to you.
I do not see any issues. The slope of the land is minimal. There's no potential for soil erosion. There aren't other structures. There's public connection to the sewer. And there's no appreciable vegetation that has to be removed to do the building.
Any other thoughts from the members of the board? Then I would request a motion be made to, yes, Mr. Bork.
So moved.
Motion has been made to approve the shoreline setback determination for on behalf of PMG Properties LLC, 446 Black Point Road. Do I have a second?
I'll second that.
Thank you very much. And any discussion? Seeing none, may we call for the roll for the vote?
Kyle Noonan,
I vote in favor.
Peter Freilinger,
Aye.
David Bork,
Aye.
Michelle Stevenson,
Aye.
and Christine Snow.
Aye.
And the determination passes. Thank you very much. Appreciate the time. With that, we will move on to item 5, the other item on the agenda. And thank you very much for the folks on item 5 for pausing for the amount of time to get through that first item. We appreciate your patience. Appeal number 2742, the administrative appeal by the law offices of David A. Laurie on behalf of State Manufactured Home, Inc. This is a continuation of the hearing that we had last month, where we determined that we would table the matter in light of the fact that there had been a court case brought. And we had understood at the beginning that there may be some rulings that would clarify things. With that in mind, before we begin the hearing and before I set the ground rules for the discussion here, I'd like to Mr. Durwood, or Mr. excuse me, Durwood, could you please give the board a brief overview of the events that have occurred since the tabling of this last month, and help us inform our actions tonight?
Sure. At the last hearing, it came up that there was a lawsuit filed by State Manufactured Homes against the city of South Portland and the town of Scarborough. That was a case that was filed with the Cumberland County Superior Court. It's been since moved to the US District Court in Portland, and the. Okay, let me start over again. There was a case filed by State Manufactured Homes against the city of South Portland and the town of Scarborough in the Superior Court in Cumberland County. Has since been moved to the Federal District Court in Portland. The town has separate representation on that case. It's still pending. There has been no decisions. There is a request for an injunction against the the city and the town, and there has been no action in the court. The concern that I had before was whether this in some way stripped this board of jurisdiction over the matter, in essence, because there is, if they were in essence appealing the code enforcement officer's decision not to issue the certificate of occupancy in the court, and also here, that creates an untenable position. I've looked at this more carefully. I've spoken with the lawyers about it. The complaint is not an appeal, although it weaves in some statements that somewhat resemble an appeal, but it's not really an appeal. It's a case that's been brought by State Manufactured Homes alleging breach of contract, some constitutional claims, a whole variety of claims. And so it's a unique situation, but my conclusion is that you should proceed with the hearing of the appeal tonight. I think that's the wishes of everybody involved, to the extent that that matters. But my recommendation is that you proceed with the appeal. I don't believe that the filing of this case changes or creates a legal obstacle. For example, eliminating the jurisdiction of this board. And that's backed up by some case law on the subject. One case is Portland Sand and Gravel versus the town of Gray. It's somewhat on point. So that's a long-winded way to say, again, that I recommend that you proceed in accordance with the manner proceeding that you discussed last time.
Any thoughts from my fellow members? Or on that basis, I think you go ahead.
Yes, based on our counsel, I think we should definitely proceed.
I'm not sure that's a matter to move for. I think we'll just go ahead and seeing the heads nodding, we'll just go ahead. I'll then reiterate sort of the ground rules we set last time. This will be not a traditional sort of variance hearing. So we'll run this really so as to make sure that this board has an opportunity to hear the facts of the case, and then make determinations of fact, and ultimately make a determination as to whether the appeal should be approved or should be denied. We'll start with Mr. Lurie again, and thank you again we appreciate your patience. We appreciate your forbearance in coming back. You'll have an opportunity to lay out your the nature of the appeal. We will then have an opportunity to ask questions, and we'll offer an opportunity for the town and the code enforcement officer to ask questions of you. We'll then draw that to a close and give the code enforcement officer and town council, or town council, not the town council, COUNCIL, but COUSEL.
Correct.
To present their case. Mr. Lurie, you'll have, of course, an opportunity to question them at that time as well. We'll have our questions. We will then offer you the opportunity, Mr. Lurie, to have a final statement. And we'll also, prior to the final statement, we'll also offer an opportunity for members of the public or other interested parties to offer their commentary and comment. We will then give you an opportunity to have a final statement, Ms. Lurie, and we will then close the hearing and enter deliberations as a board. With that in mind, we swore in a number of people last month. Are those people also going to be testifying here today? Are there members who will be testifying?
We have
So
two.
could you guys stand up and raise your right hands, and we'll swear you in? Do you swear that the testimony that you may or will give to this board is the truth as you know it to the best of your ability? Thank you.
Sorry, I wasn't on that one.
Thank you. Okay, Mr. Lurie.
Thank you, Chairman Furlinger and the board. We're going to do things a little differently last time because it went so well last time. I'm going to first introduce to you Teresa Desfosas and and her daughter Tina Smith. And then I'm going to follow up with some of the legal points that arise out of their testimony. So, come on up.
And if you could, for the record, just state your name and if you could go one at a time, just to manage the microphone issue.
Sure,
Yeah.
sure. My name is Tina Marie Smith. I'm a resident of Scarborough, lifelong resident of Scarborough.
I'm Teresa DeFossis, President of State Manufactured Homes.
I'm here on behalf of my mother, Teresa DeFossis, who suffers from low vision and cannot easily read at night. And also on behalf of our 4-generation family-owned and operated business, State Manufactured Homes. We've been in business for over 80 years in Scarborough. We are here this evening to ask that you remove the condition imposed by the zoning administrator to our building permits and direct that a certificate of occupancy will be issued to State Manufactured Homes for specifically 507 Opal Drive and promptly upon application for each other manufactured home located on Opal Drive in Pinecrest, which is connected to the South Portland sewerage system at the sewer connection identified in the agreement dated December 31st, 1981. This is a difficult appeal because the original sewer agreement was immortalized in a contract dated December 31st, 1981. And I will try to explain the historical significance of this 1981 agreement. And Teresa is here with me in case you have any questions. Pinecrest was initially known as Pinehaven Trailer Park. It was built in the 1940s by the Wilkinson family. In the early days, it served as a place to park trailers for workforce housing following World War II. In fact, there are over 220 small trailers that were located there. At this time, the largest home located at Pinehaven was 8 feet wide and 30 feet long, which equals approximately 240 square feet. The DeFossis family purchased Pinehaven in 1969 from John Wilkinson, and we changed the name to Pinecrest. As you may or may not be aware of, manufactured housing communities are different from typical subdivisions because the individual homes are owned by each resident and the land and infrastructure is developed and remains owned and maintained by the community owner. A community owner is responsible for all of the infrastructure, including the roads, power pedestals, solar streetlights, water mains, all services to the individual homes, the sewer pump stations, and internal sewer mains up to the common sewer connection with the municipal sewer system. The Pinecrest community is entirely located in Scarborough and connects to the South Portland sewer system at the entrance to the community on Pinehaven Terrace. A short time after my grandparents and my mother purchased Pinecrest, my family began receiving unflattering input from officials and residents of the town of Scarborough and the city of South Portland regarding the character of the homes. The community was referred to as a trailer park in the most derogatory way, and quite frankly, we agreed that it was deserving a much-needed makeover. We began to plan for the future. In 1976, the federal government took the important step of regulating the construction and inspection of all manufactured homes, known in our industry as HUD code homes. This ensured the safety and construction standards of all manufactured homes. They addressed window egress, for example, hallway widths, things of that nature. With HUD code homes standardized construction, this enabled the industry to produce larger and more specialized homes, and manufactured homes became a viable option for a lot more people as the homes grew from, say, 250 square feet to over 2,000 square feet today. As the homes grew larger, the land at Pinecrest did not expand, however. We faced the realization that Pinecrest could not continue in that condition. Now well over 30 years old, the infrastructure was outdated and perhaps dangerous in some cases. For example, the water service to each home was only a 1-inch copper pipe. If people were taking showers at one end of the street, there was absolutely no water pressure at the other end. Overhead power lines were touching the roofs of some of the homes. The sewer mains were old cement pipes that allowed for massive infiltration problems, and the sewer pump station was in need of replacement. Some homes were so close to each other that it presented a dangerous situation. We invited the Scarborough Town Manager, members of the Planning Board, and the Town Council to see the existing Pinecrest and explained our plans for its reconstruction as a modern manufactured housing community, similar to Hillcrest. This plan also required securing the right to the continuation of the sewer treatment arrangement with the City of South Portland. After visits by Scarborough and South Portland officials, it was agreed that we should replace the existing 217 grandfathered sites with larger sites placed further apart and to replace all of the infrastructure. We agreed, and my family received legal, written, and recorded confirmation that the City of South Portland would always accept Pinecrest sewerage as long as we did not exceed 200 homes. This understanding was memorialized by an execution of a 1981 agreement with the predecessor to State Manufactured Homes and recorded in the Cumberland County Registry of Deeds in 1982. The contract that was executed on December 31st, 1981 was drafted by Bill Dale, who was an attorney for South Portland, working with our then attorney, Ted Kurtz. It was executed by Robert Ganley, then the city manager of South Portland, and my grandmother, Agnes DeFossis, who was then the president of State Manufactured Homes. You have a true copy in the materials we provided, and it's marked as Exhibit A. Relying on the 1981 agreement, we notified all residents that they would have to move within 5 years. We then reconfigured the sites, replaced the, sorry? No. Oh, okay, I didn't know if it was a question. Relying on the 1981 agreement, we notified all residents that they would have to move within 5 years. We then reconfigured the sites, replaced the overhead power lines with all underground power, replaced the water mains, sewer pumping station, and all of the roads. Over the next several years, we replaced the 217 pre-HUD mobile homes with 112 HUD-approved manufactured homes, intending to eventually get back up to the 200 homes that had been agreed upon. Remember that the homes in the old Pine Haven were 240 square feet, and the new manufactured homes were 2,000 square feet, with many having 1 or 2 car garages. At all times, all sewage from Pinecrest was delivered into the City of South Portland sewer system from our private system through a common connection described in the 1981 agreement, with State Manufactured Homes continuing to pay volume user charges set by the City of South Portland. State Manufactured Homes' consideration for this agreement was our commitment to improve our community by upgrading and maintaining its internal systems, including the sites and the electrical and sewage systems. We were never asked to pay to connect to the South Portland sewage system, and we never paid to connect to the South Portland sewage system. We did, however, pay the sewer user charge based on the amount of water metered by the Portland Water District. In 1995, the town and the city executed and recorded a certain joint sewer service agreement attaching a map of the area to be served as Exhibit A and a model service agreement proposed as Exhibit B. We were not a party to this agreement, and we did not even know that it existed. We continued to rely on the 1981 agreement for the sewerage disposal at Pinecrest. It has become clear that the City of South Portland and the town of Scarborough forgot about the 1981 contract with us. In recent years, the need for affordable housing has certainly increased, and in 2020, our family decided that we could afford to expand the number of homes in Pinecrest by 31 homes, from 112 to 143. And because the Pinecrest community is in Scarborough, we sought zoning and subdivision approval from Scarborough and relied upon the 1981 agreement with South Portland addressing the disposal of sewage from Pinecrest. South Portland was notified of the expansion and informed our planners that the City of South Portland had no jurisdiction concerning the expansion. We applied to the town for approval of the expansion from 112 to 143 manufactured homes, with no new connection being made between the existing Pinecrest private internal sewage system and the City of South Portland system. As part of the Scarborough approval process, the City of South Portland certified to state manufactured homes and to the town of Scarborough the adequacy of the collection and treatment capacity of South Portland sewage system to handle the increased flow of the 31 units through the existing connection to the city sewer specified in the 1981 agreement. A true copy of the city certification is included in the materials furnished to you. Our application for the 31 homes was reviewed by town staff working with the Scarborough Planning Board and included the increased flow of sewer waste through the existing connection in the South Portland sewer system. The Planning Board recommended approval to you, the Board of Appeals. Brian Longstaff, Planning Director and Zoning Administrator, was involved in the planning and appeals board approval from application to final board approval as a special exception of Pinecrest as a non-conforming use. Among the specific findings made by both the planning board and this board was the proposed use will not create unsanitary or unhealthful conditions by reason of sewage disposal, emissions to the air or water, or other aspects of its design or operation. Brian Longstaff's subsequent finding explaining the reason for his insertion of the condition of the building permit issued for 507 Opal Drive and asserting his independent right under the town zoning ordinance, chapter 405, section 4D and E, that he must ensure that an application for the building permit include evidence of adequate sewage disposal cannot be reconciled with the board's decision approving the expansion as meeting all requirements for this special exception in December of 2020. Neither I nor anyone else advising state manufactured homes can understand why Brian Longstaff, as planning director, having knowledge that Pinecrest had for more than 50 years been connected to the South Portland sewage system and continues to be connected to the South Portland sewage system, and having been privy to all approvals, has done the bidding for South Portland to pressure state manufactured homes to invalidate the 1981 agreement and to generate a condition for issuance of a certificate of occupancy totally unrelated to the realities of sewage disposal at Pinecrest. On April 28, 2021, Brad Weeks, who we were informed had recently replaced the former Director of Water Resource Protection in South Portland, for no stated reason, emailed our project engineer, Andy Johnston, a document that Mr. Weeks called an updated sewer agreement. Brad Weeks' email asked that Andy Johnson take a read and let me know from you any questions. The sewer agreement Weeks forwarded was not consistent with the 1981 agreement and stated it superseded the long-standing 1981 agreement. The proposed update is on page 43 of your materials. It did not contain South Portland contractual obligations for Pinecrest sewerage up to 200 homes. It did not impose a connection fee where no new connection, it imposed a connection fee where no new connection was created, and it stated that this new sewer agreement superseded all prior agreements, including the 1981 agreement. Because of these terms, we informed Andy Johnston that state manufactured homes would not sign the Weeks proposed document, and Teresa explained the reasons and offered to meet with Mr. Weeks and South Portland's attorney, Sally Daggett, which we did. We offered to pay the requested connection fee in escrow pending a court determination of the enforceability of the terms of the 1981 agreement. That proposal was rejected by Attorney Daggett, who replied that state manufactured homes either sign the Weeks agreement and pay the demand fee, or South Portland would no longer provide Pinecrest sewage disposal. At this point, in September of 2022, the infrastructure for the expansion was close to completion and the homes were arriving for the manufacturer. To date, we have invested $2.5 million in this expansion of the infrastructure and have an additional $2.9 million in homes that we cannot sell because the town of Scarborough will not issue occupancy permits. The carrying costs that we have been forced to incur are $109,977 as of today. Having been kept fully informed of the progress of the Pinecrest expansion to put financial pressure on state manufactured homes to accede to the contractual demands by interfering with our expansion of Pinecrest, South Portland made the decision to invoke Scarborough and its extortion by notifying Scarborough of its threat, and has the audacity to submit a memorandum authored by its attorney, Ann Brad Weeks, to this board, which does not disclose the city's over 42 years of providing sewage disposal to Pinecrest arising from its 1981 agreement, contractual obligations, or even mentioning the 1981 agreement at all. The city of South Portland has also not admitted in their submission that they cashed the check for $35,572, covering the erroneously computed connection fees for the 31 sites. We paid the egregious sum under protest on October 27th, 2022, and they waited until January 4th, 2023 to cash the check. Therefore, the town of Scarborough has no municipal interest in supporting the extortion tactics utilized by South Portland and its attorney, Sally Daggett. State Manufactured Homes does, in fact, have a binding sewer agreement with the city of South Portland dated December 31st, 1981, providing sewer disposal for up to 200 homes, and the city of South Portland has cashed the check that was demanded from us. In closing, I ask that you remove the condition imposed by the zoning administrator to our building permits and direct that a certificate of occupancy be issued for 507 Opal Drive and for subsequent homes located on our approved expansion at Pinecrest. Thank you.
Thank you very much. At this time, should Mr. Lawyer, would you like to make a follow-on statement, or should I open this to questions from the board? Or
I think the board should ask questions now.
I'd appreciate that. So I'll open that and start with not Miss Snow, as she appears.
I have no questions.
Okay. Gotcha. How about you? Okay. No questions at this time. Okay. Mr. Bork?
Yeah, follow-up question regarding the 1995 agreement, which you claim was never approved by State Manufactured Homes. You had no knowledge of?
That's correct.
And how were you informed that that actually happened? When did that occur?
As part of this whole procedure of trying to get this matter off dead center,
So
we were
this is
advised that the
last year, 2022, as
Yeah.
you were going through this process,
yes,
that's when you discovered that.
that's when the city of South Portland said that they wouldn't honor the 1981 agreement because of the 1995 the 1995 agreement was between the Scarborough Sanitary District, the town of Scarborough, and the South Portland
Okay.
Sewer Department.
So it's between the city and the town only. And
Right.
you were not a party to that agreement.
That's correct.
Thank you.
Mr. Hughes?
So I don't have any questions now, but I would like the ability to perhaps ask you questions after we've heard from the town and the city. Is that appropriate?
Yeah.
Okay.
Yes.
Sure.
Thank you.
Now, just for the purpose of going through this, I just want to make sure that we're asking questions now as well, if that's okay. I have a question about the 1981 agreement.
Okay.
There's a clause in the 1981 agreement that clause 5 of the city rules and regulations that seems to allow the city to amend its regulations or amend its operation of the sewer and sewer agreements from time to time. And that's contemplated in the 81 agreement, so that while the 81 agreement has not yet been superseded, it contemplates changes to law and changes to practice. How do you interpret that clause of this contract in relationship to both the 1995 joint arrangement that the city subsequently made with the town, and with the requirements they put on you in order to connect to the sewer today?
As far as we understood it, during the 1981 agreement, was the city of South Portland absolutely guaranteed that we could have sewerage for 200 homes. That was why we went forward with the remodeling and the total reconstruction of Pinecrest, was with the understanding that we would not suffer from less homes in the future. To me, the city having having the ability to change doesn't change the amount of homes. It changes how they charge, what the fees are, whatever else they want to get into. But certainly does not negate their commitment to us to have sewerage for 200 homes.
Yeah, that'd be fine. Mr. Lawyer. Okay. No, that's fine. That was my question. So I appreciate you responding to it. Mr. Lawyer, I guess you have the.
I'll be right here.
I should have let them go last time then. Seriously, why don't I start off by answering Mr. Freilinger's question, and then I'll get into my spiel here, which is legal issues, basically. Although there's a reservation in the 1981 agreement, it pertains to the rules governing we understand it to pertain to the rules governing the treatment of waste, the operation of the treatment plant and so forth. This is about the time the Clean Waters Act came along. And more to the point, though, if you look at what Sally Daggett presented to you, which is the South Portland ordinances, they don't in fact apply to this at all. I call your attention, which she did not call to your attention, to section 22-2, which is the scope of the South Portland, the whole chapter deals with sewage. The section, I'm sorry, I don't have in front of me the page reference to that, but section 22-2 says, hereafter, any person owning any buildings within the city of South Portland, this is what's labeled scope. Hereafter, any person owning any buildings within the city of Portland, which is the source of sewage or industrial waste, or proposes to erect such building or structure, shall conform to the requirements of this chapter. Okay, well, the chapter governs buildings within the city that discharge waste. It does not apply to Pinecrest, which is outside of the city and discharges waste under the 1981 contract. It doesn't affect it at all. Nothing in that chapter applies to it, despite the arrows drawn by Sally Daggett. It's just not on. So it's sort of irrelevant anyway. I thought it was a red herring till you asked that question, because that's what it is. In fact, besides, this board cannot interpret the South Portland ordinances. I mean, it's really beyond your scope. I'm going to go through a bunch of other things which you may or may not, your attorney will tell you whether you can consider them or not, whether they are things which you as an administrative board can consider or not, okay? Because you can't decide constitutional issues, although there are plenty here. I'm going to identify a number of them that you're going to bail the town out of if you, in fact, or at least you will make the TRO application, which was made originally to the Superior Court and is now pending in federal court. You will make that issue moot if you grant this appeal. So this is not a waste of your time because it's in court. If you grant this, you'll obviate the necessity of our going through temporary restraining order briefing and arguments in the Superior Court or the federal court, wherever this case ends up, or wherever that issue ends up being decided, because they will have their permits and they will be able to sell their houses under the preliminary mandatory injunction.
Mr. Lawyer, in the interest of saving everyone's time, though, we are not going to make a constitutional
Right.
Judgment of law here. We're also not, we're likely not going to make a judgment of state law here. What we're going to do is make an administrative judgment. So if you could do us, if you could just use our time the best way that we can and focus on the administrative issue itself and not get into the issues that have been raised at court, which are in their jurisdiction. They're not on our docket today.
Well,
And just help us out on that. We would appreciate it.
I will try. This case is unique, to put it mildly. And 50 years of practicing municipal law, I've never seen or heard of anything like this. One municipality creating a condition deferring a decision to another municipality which has a vested interest to the tune of the connection charges, at least. I mean, that would raise due process concerns in any context. Your attorney there will advise you on that stuff. But the fact is that this is a unique situation. It's unfair. You heard what happened. You heard there was an agreement in 1981 and that it was relied on by the DeFossis family. And the bottom line is that the findings that were made on December 10th, 2022, we forced them to make findings of fact under the Freedom of Access Law. That's the date that the law court says triggers running of appeal periods. That decision was made on November 10th, and we filed this appeal on December 6th. So it's probably before you to consider the condition as well as the administration of the condition. As to the administration of the condition, the DeFossis family has bent over backwards. I don't know if I'm pronouncing their name wrong, but I will continue and do the best I can with that. But they have bent over backwards. They have tried on numerous occasions to give 3 times at least. They've given draft agreements to the city of South Portland, which says they're not good. They're no good because they don't get rid of the 1981 agreement. Well, I mean, they had an agreement in 1981, which they no longer want or no longer recalled. And in any case, they're bound by it. And they can't shut it as a practical matter, not just a legal matter. This is one thing that Tina and Teresa neglected to say. There are 112 units already connected. This is the 113th unit we're talking about, home, 113th home we're talking about. And the South Portland cannot shut off the sewer for any of those just because they don't want to see 113th home contributing waste to the same stream. It's the same stream going the same way it always has. It's an empty threat that South Portland will ever shut off the system, and therefore it's not something that the CEO can use to deny the permit, and not something this board should consider in deciding whether to issue the certificate of occupancy for the 113th unit. They're not going to shut off 112 other units, homes, which are there. Excuse me, I'm starting to talk like Mr. Longstaff, who refers to this still as a trailer park, I understand. And these are homes, these are people, there are people out there who are homeless right now. There is a shortage of affordable homes, or homes even, in the Portland area. And they're keeping these homes off the market because they won't give a certificate of occupancy.
Can I jump in, Mr.
Yes.
Laurie, do you mind if I interrupt with a question? For
Yes,
you?
you go right ahead.
I just want to make sure I understand your client's position. Is it that the town should have issued a certificate of occupancy because the 1981 agreement is still in effect and satisfies any requirement that the town has imposed?
That's part of it. They should not have imposed the condition to begin with, but because it's still in effect, the condition is met. It's not reasonable to require a new agreement when they already have a legally enforceable agreement.
Okay.
That's our position.
Can I just follow up on Kyle's question? Just following up on Kyle's question. Are you appealing the condition that was set or the non-issuance of this?
Both.
I mean, I'm trying to see that in your appeal application. It says unreasonable failure to grant application
Well, it's the granted initially.
11,
And-
15, 22 for certificate of occupancy. I'm not seeing the part where it says unreasonably applied a condition to the,
Oh, to the building permit?
Yeah.
Yeah, but it's timely in terms of the building permit. It's before I don't think you can separate, I think I said this last time, I think it's like lightning and thunder. You can't really separate the two of them because they're supposed to happen seriatim. First you get a building permit. Originally, we were told they weren't going to get any building permits, and they had these pieces of homes sitting there waiting to be assembled. Okay, so they were then told, when we told them that they can't be assembled safely without transformers. At that point, the city relented and said, okay, we'll give you building permits, but we're going to look at this again. That's what we understood it was going to be. We're going to look at this again, at the time of certificate of occupancy. And it's really a matter of duress at that point too. I mean, they were under economic pressure. They had these things arriving on site. They needed to be assembled so they could be sold. So they could be assembled and sold. So they didn't even accept a building permit. I mean, these things are done informally. It's not like a developer coming in and saying, I want to build 500 homes here, and here's my application. And in the course of dealing with that application, the town puts a condition on the approval of the 500 homes that they can only be sold to low-income people, whatever.
Sure, that is kind of,
It's not like that kind of condition, is what I'm saying. These things happen like that.
but it is interesting that SMH essentially voluntarily assumed that risk along with other risks by ordering materials for construction prior to the issuance of a building
No,
permit.
they relied upon your approval 2 years ago. They came here, and it's only after you approved the expansion of it under HUD regulations, the town doesn't get to decide anything more about it, even
But to be clear, though,
pads.
the zoning board does not approve building permits. We don't approve construction. We don't approve new developments. That's not our role as a zoning board.
No, but your role as a zoning board was to approve the expansion, the 31 units. And as a result of that, they went ahead and ordered them. And South Portland was involved in that decision. And so was Mr. Longstaff throughout.
But we approve on the basis of very high level facts, but and then pass on to staff, the planning staff, the discretion and the timing and the decision for the ultimate issuance of a permit. We don't. I can't after this meeting sign a document saying you've got a permit. That's not what we can do.
Understood, but in court, and this will end up in court if you
Sure,
don't,
yeah,
yeah, probably, in court, if you make a decision on a matter of fact, you make a factual determination, there's a rule which Mr. Parkinson, my mind went blank, Mr. Parkinson can tell you about, called collateral estoppel and issue preclusion, which afterwards binds everyone to those decisions, those underlying factual decisions. And if we're in court now, there wouldn't be any question about this. He'll give you instruction as to whether that's applicable here. Our position is that the board, having found that there was adequate, that met all the ordinance requirements for septic disposal, is now bound by its own decision before that, and the town is bound by it, and so is South Portland, since they participated in that proceeding. I'm sorry, you want to talk?
I just want to explain a little bit. When we came before the planning board here in Scarborough for a permit to expand, that was the infrastructure of the manufactured housing community expansion for 31 homes. In order to get the homes delivered, we have to order them from the manufacturer of the homes in Pennsylvania. And it takes, at this point, with all the COVID and all the rest of the supply chain issues, it takes as long as a year or two to get the houses. When we received planning board approval, we hired the contractor to build the infrastructure. He started that, we ordered the homes. They all fell into place. Nobody raised the issue of the South Portland sewer before that planning board decision was final. We went ahead based on the decision given to us at the time. We assumed that everything was done. The houses land, we set the houses up, and then all of a sudden everything goes haywire. It's not anything that we had any premonition that was going to happen. We assumed because everything was done. And we've got the homes, we've got the infrastructure, we paid our contractor $2.5 million. We've got the homes sitting there. And now we're between a rock and a hard place. And there's nothing we can do other than appeal to you and go to court. So when we're not threatening to go to court, we have no options.
And my former chair here would make the statement here. We understand the emotions that you're going through. We understand the real economic loss that you're incurring as this kind of moves along. At the same time, our duty as a board here is to hear the appeal on the basis of the facts as we hear them. And we've heard one side
I
of the facts so
understand,
far.
sir, very
Um,
well. I'm
but-
just trying to explain to you the way that this whole thing goes down. It's not like it all just happens. We did what we were supposed to do.
Again, the fact that that incurs an economic loss, though, really is beyond the scope of what we would consider as a Board of Appeals. So, Mr. Laurie.
We're here on the issue of the proper administration of the ordinances of the town. And here they're being perverted for the benefit of the city of South Portland, to the detriment of the town of Scarborough itself, as well as the people out there who would want to live in these homes if they could buy them, but we can't sell them.
We unfortunately, this board does, actually, I'm going to say unfortunately, this board doesn't consider those issues of policy or of town benefit in determining whether there's been an administrative wrong that's taken place.
No, I'm speaking to the town ordinances. Where does it say in the town ordinances that he can arbitrarily, that the code officer can arbitrarily, when he knows there is sufficient septic disposal, that he can arbitrarily either put a condition on or deny a certificate of occupancy afterwards? I just don't see it in the ordinances. And if you read those ordinances that way, they would be unconstitutional. As Mr. Parkinson said, will tell you, if you have an opportunity to read an ordinance in a way that it will be constitutional rather than in a way where it will be blatantly unconstitutional and void for vagueness, which is the way that it's being put forward in those findings of fact that we extorted. That's the only thing we got to extort. I mean, they're trying to extort them to give up their contract rights. This is wrong, and I think everyone on the board knows it's wrong, and you have the power to redress it. And I think that Durwood will tell you that. Thank you.
Thank you. We appreciate that, Mr. Laurie. With that, are there any further questions from members of the board? No. As Mr. Noonan noted, we might reserve additional questions after we hear from the town and the code enforcement officer. But with that, we'll turn it over to the town and ask you to describe your position.
Good evening. I'm Phil Saucier from Bernstein Shore and represent the town in this matter, the town's code enforcement officer. And I'm going to take David Laurie's lead, and I'm going to first have Brian Longstaff speak and describe the process he went through when he issued the building permit and the issue around the certificate of occupancy. I'll come back and address a few legal issues.
Thanks, Mr. Saucier. Thank you.
So, yeah, I'm happy to describe the process. I'll just mention a few things first.
Actually, Brian, if you could just start off by saying who you are.
Okay. I'm Brian Longstaff. I'm the zoning administrator, code enforcement officer, local plumbing inspector, certified floodplain manager for the town of Scarborough.
Thanks very much.
22 years experience. So when we issue permits for any development, let's start with a typical subdivision. There's always a letter of ability to serve or capacity to serve that's issued by our sanitary district. That is not a permit for an individual home. So when the subdivision is approved and they come for their first building permit, we expect to see a sanitary district permit. As Mr. Laurie already stated, this is a kind of a unique situation. Scarborough Sanitary District is not the district that receives the septic or the sewage waste from the development. So we're looking for some approval from the South Portland Sanitary District. They issued a capacity letter, an ability to serve letter. They said they have the capacity in their system to serve however many homes that the Pinecrest development wanted to have. That's typical. We know the infrastructure is there, yes. Just like we know the infrastructure is there for the Scarborough Sanitary District. That doesn't give anyone the right to occupy a home unless they have paid their fees and gotten their sanitary district permit. We will not issue a building permit, let alone a certificate of occupancy, unless they have that. We went out of our way to help these folks out. We in no way wanted to harm them. We came to understand that they were backed up. These units were coming. They needed to place them somewhere. We agreed to issue building permits with the condition so that we could then make sure that they had a legal and approved place for their septic waste to go. That's how we approached it. And that's why the condition was there. They didn't appeal that condition. They agreed to it. When they came in and asked for the certificate of occupancy, I asked if they had their agreement in place. They said they did not. I said I could not issue the certificate of occupancy. I am legally bound not to issue a certificate of occupancy if I don't see a legal, or if they don't demonstrate a legal and approved place for that sanitary waste to go. It's just that simple. Would you want to move into a home if the toilet was going to overflow because the waste wasn't being accepted somewhere? It's not only unhealthy and unsafe, it's just not practical. They had the control and the ability for over a year to resolve this issue. They want to make the town the scapegoat here, but it's not our fault. I have no control over what the city of South Portland does. I would love it if the city of South Portland would agree to their demands, but that's not happening, and I have no control over that. I wish that SMH would agree to the city of South Portland's demands, because then I could issue the certificates of occupancy and I could escape all this defamatory and derogatory commentary that's being offered. I would love to issue these certificates of occupancy. I would love nothing more to see those homes occupied and all that good stuff, but I can't do that. And in your packets, I've pointed out why. Simply said in chapter 405, section 4D and E, the code enforcement officer must ensure that an application for a building permit include evidence of an adequate sewage disposal. Now, whether that's a private on-site system or if that's a sanitary or public sanitary sewer system, one way or the other, sewage has to go to one of those two things, or the third option is a licensed discharge, and that ain't happening for Pinecrest. So that's in addition to that, we also have in our state rules, wastewater disposal. Any wastewater as defined in these rules must be disposed of by one of the following methods: on-site disposal, public sewer, licensed discharge. So my hands are tied. They could sign the agreement, or the city could agree to their terms. I don't care which way it goes. I have no vested interest in that. I just want to be able to issue the certificate of occupancy. But I wanted to point it out that the letter that was provided for the approval by the planning board for their expansion was a capacity to serve, the ability to serve letter. That's a very standard sort of thing for a sanitary district to provide for any development in town. It just so happens it's not coming from Scarborough Sanitary District, it's coming from South Portland. That doesn't mean that they automatically have individual permits for each one of those dwellings. It simply means there's the capacity to serve those dwellings. Any fees, any permit applications, any of their system, which I don't even know what they require, but I need to see that demonstrated, and it hasn't been demonstrated, and here we are.
Let me give the board a chance to ask
Sure.
questions. Yeah, David?
Yes. Mr. Longstaff, yeah, I just have a question regarding the existing agreement between State Manufactured Homes and the city of South Portland, the sewer agreement dated 1981, I believe. Were you aware of the fact that they had an existing agreement in effect?
I had not seen the agreement until all of this started.
Okay.
I
So
have no
you made
knowledge of
this-
it.
You made your decision based on limited knowledge, is that?
Oh, no. By the time I made my decision, I was aware of it.
You're aware of it?
Yes.
Okay. And did you in fact receive any correspondence from the city of South Portland informing you that there was a problem on their end?
Yes.
Okay,
I don't know that it was correspondence. I believe it was a phone call.
okay. All right. That's all I had.
Well,
Okay.
just following up on that, what's your position as to whether the 1981 agreement can or cannot satisfy the town of the town of Scarborough's requirements?
I have no position on that. I'm relying on what the city will accept. If the city gives them a sanitary district permit for each unit, if that's their process, that would demonstrate that the sewage can go. I know the infrastructure's there. I am aware of that. That doesn't mean that it's legal for them to deposit sanitary waste into it. No more than it is for somebody to hook up to the Scarborough Sanitary District without a permit. Even though the infrastructure may be there, the stub may be to the property line, they can't hook up to it without a permit. And I'm sure that's either theft by unauthorized taking or some other legal problem, but he can't do it.
So it's your understanding the 1981 agreement isn't enough.
I have no opinion on it because I don't care. It does not involve the town of Scarborough. It's an agreement between State Manufactured Homes and the city. It matters not to me what that agreement says. All I want is for somebody to demonstrate that they have the approval of the district to accept that waste for each individual permit that I issue.
Mr. Longstaff, I'll ask maybe a similar but related question to the 1995 agreement between the joint agreement between Scarborough and South Portland, where the town is a party to that agreement. Were you aware of that agreement at the time of number one, entering into the conditional building permit with the conditions attached, or when you withheld the certificate of occupancy?
I was aware of it. I was not intimately familiar with it, nor do I think it's applicable to the situation that we have here.
Okay, thanks. Sherwood, I want to give you an opportunity
Yeah,
here.
I have a question, Brian, about, I think I heard you said that they agreed to the condition of approval, that they would have to produce a new sewer agreement for the city of South Portland. Can you expand on that? How did they agree? Verbally, writing?
They may not have agreed. They didn't contest it. They didn't appeal that.
Okay, they didn't say, oh, we're fine with that as a conversation or an email or a letter or anything. They didn't, you're saying they didn't appeal that decision, which was part of your building permit approval on November 7th, 2022. That's what you're saying. Okay.
Michelle?
Well, I guess this is maybe a question, or maybe you can, this is my understanding, and tell me if I'm right, because I'm trying to wrap my head around this. Your position was you needed to hear from South Portland to say they agreed, State Manufactured Homes agreed to the agreement, and they paid all their fees, and then you could issue.
Either that or that the city agreed to State Manufactured Homes, because they've rewrote the agreement, I think, a couple of different times. Again, not my circus, not my monkeys. I'm just looking for somebody to tell me it's okay to go ahead and issue that permit because everything is in place to legally dispose of that septic waste, that
And they have
sanitary
not
waste.
done that.
They have not done that.
Thank you.
Brian, one further point of clarification. You mentioned on sort of a development, a generic development in Scarborough, there would be a building permit would be approved or building permit would be granted. But say the development was envisioned to be 40 units. It's not that therefore each unit has been automatically granted the right to be built and to be hooked up at that point. Each unit is then subject to a further review or a further application process. Did I get that right? I just want to understand.
Well, the development would be approved based on the density that's allowed in that zone, which
Mhm.
could be 40 units or
Yeah,
100
exactly.
units
Yeah.
or whatever it is. But then once that approval for that development happens, then we're free to start issuing building permits as those applications come in. They have to demonstrate many things. They have to demonstrate, for example, in Scarborough, a growth permit, and they have to have electrical permits. They have to have plumbing permits. They have to have all of the necessary permits. They have to provide plans that we can then review for code compliance. We don't have to do that with manufactured housing. It's regulated by someone else. We still issue permits for the garages and the things, the slabs and the things that are poured, but there's still a building permit process. There's still an electrical permit. There's still a plumbing permit for the hookup to the system. All of those things are checked, and then we issue the certificate of occupancy. And that's how we normally go. And we use Hillcrest as a great example. I mean, the permits come in with all the information. We're able to issue them. We go and we issue the certificates of occupancy when they're ready, and it goes seamlessly. But that's on Scarborough Sanitary District. And each of those units get a Scarborough Sanitary District permit.
Any other questions? Ms. Snow? Okay. With that in mind, then, Mr. Saucier, if you could. Could we do that after Mr. Saucier, if that's okay, Ms. Riller? Yeah.
Thank you. And I can't sort of summarize better than Brian did. So I think that's a good summary of the process. I did want to come back to a couple of things. And Attorney Parkinson brought up, I raised an issue last time about jurisdiction. I want to raise it again and at least preserve it, which is it's still not clear to me that the building permit was appealed. I think it's just something that board's going to have to determine. The application before you is an appeal of the non-issuance of a certificate of occupancy. That's very clear. I think Attorney Laurie made that clear last time. He has now said he may be appealing the building permit, but the appeal as it's in front of you is an appeal of the non-issuance of a certificate of occupancy, and you cannot attack a building permit condition without appealing the building permit itself. And the courts have made that clear. There's a case on point. If you want to know the case, it's Salisbury versus the town of Bar Harbor. An appeal of a certificate of occupancy may not, however, substitute an appeal for the underlying permit. Right. So the idea is that if what they're attacking is the condition, that should be in the guise of an appeal of the building permit. So I'm just going to raise that. You can decide what you want to decide on that, but I do think it's an issue that needs to be decided. There's a number of questions about the agreements, and what I would say about this, and Brian, I think, addressed it very well. The town of Scarborough is not a party to the 1981 agreement. It has neither the authority nor the jurisdiction to interpret the rights under that agreement. It's simply not a party. I actually don't think this board has the jurisdiction to interpret that agreement. That is something for the courts. What was in front of Brian was, what is there adequate sewer to be able to issue a building permit? In this case, he did defer that, and so it's a certificate of occupancy. And as he noted, and if you look at the building permit packet, one of the items he needs to see is that permit from usually from the Scarborough Sanitary District. That's what shows it. He doesn't have that in this case. It is unusual in that there's a particular part of town that's actually served by the South Portland sewer system. So that's where he was not able to say that it met the standards of the building permit requirements and the sewage system rules of the state. So he is in a bind. He doesn't have that. He did testify that he was notified by probably a phone call from the city that they would not issue, that they would not accept sewer. And now you have in your packet also that in writing. So I just want to point that out. That is in writing from the city. It was both in a reference in a letter from Attorney Alan Beagle to Sally Daggett, an August 9th, 2022 letter that referenced a prior 1 year earlier email, also from Sally to Alan, that said, in order to provide sewer service to Pinecrest, here's what you need to do. We're not going to do it. The letter, and then there was another letter in the packet dated November 11th, 2022 from Sally Daggett that said, South Portland will refuse to provide sewer service if you do not satisfy these conditions. So that information is in front of Brian. He can't unsee that or unhear that. And so in his professional judgment, he's not able to issue a certificate of occupancy if he has information that they may not be having sewer service. So it's really a straightforward question from the town's perspective. The town takes no position on that 1981 agreement. It's not a party to that agreement. It does not have any position on what amount is paid or not paid or what the language in that agreement is. It simply does not care. It's not a party. A couple questions about the 1995 agreement. Again, it's in my view not relevant, but if you do, but I will address it briefly because two people have asked questions about it. It's a fairly simple and straightforward agreement in 1995 between the town of Scarborough, the Scarborough Sanitary District, and the city of South Portland. And what it says is the city of South Portland agrees to provide sewer service to a particular part of a town, and the part we're talking about right now. That's all it says. If you read it, there's actually no obligation for the town of Scarborough in there. There's no obligation for the town of Scarborough, for the Scarborough Sanitary District. The only obligation is, and there's really no obligation per se. All it says is the city of South Portland will provide service subject to its ordinances, rules, and elsewhere. So that's all it says. I think it's not really relevant to this particular item, other than it provides the background for why we're here today. It's sort of that, as part of that system.
Can I jump in with a question?
Absolutely. Yeah.
What does Mr. Longstaff need to show adequate, what's the language exactly? Adequate sewage disposal? Like, what is that?
He needs an indication from the city of South Portland that it's going to accept sewage for each of these units in the same way that he would process any building permit application, as he pointed out. It's easy for him in the normal course because and Brian just showed it to me, one of the pages of a building permit is there's something from the Scarborough Sanitary District where they check off the boxes, make sure that it's adequate, meets the standards, and they give the approval. He doesn't have that in this instance, so he needs something like that. He needs something from the city of South Portland saying that they will accept sewer from these units. So then he can then say that it's suitable for occupancy. He's not, he can't say it's suitable for occupancy if they can't show that they're going to accept sewer. It's a conundrum, but it's no different than any other building permit in town.
And maybe to follow up on that, again, related to the 1995 agreement, effectively, the town of Scarborough agreed to accept the city of South Portland as the assessor of adequacy for hookups in the area defined under, I think it was either Exhibit or Schedule A and B to that 95 agreement.
I would not read it that way. It doesn't say anything about what the town of Scarborough does or does not do, actually, in the 1995 agreement. The only obligation in there, or I keep
Well, it
using. the
does
word
say we
obligation.
don't provide sewage there.
It simply says, if you, it's interesting. It doesn't say the town of Scarborough does anything. It doesn't say anything. The Scarborough town is a signatory to it. I think it's essentially because they're acquiescing to something that's in their territory.
Yes, and that's.
So, they're acquiescing to the city of South Portland providing service within the town of Scarborough to the extent that they're agreeing that there's any sort of quote obligation in there. But the only thing that agreement says is that the city of South Portland will service a particular area of Scarborough.
In acquiescing, though, do we give up our right to challenge? Does the town effectively give up its right to challenge any dispute that might emerge between South Portland and whoever's in that zone or whatever it might be?
Oh, I take issue with the way you're describing that.
Yeah,
The town is not taking a position on a dispute between South Portland and the developer here. They're not taking a position on that dispute. We're not a party to it. What that agreement did not do is obviate Brian Longstaff from having to satisfy the fact that the building permit conditions were met or certificate of occupancy permissions were met. He still has to do that in his professional obligation. There's nothing in that agreement that says he can overlook whatever part of the code. He still has to apply the code when he's issuing permits. And so again, the town is agnostic on that agreement, and maybe you'll hear from the city of South Portland. You've already heard from the other part of the agreement.
Respect to this.
In terms of how they get to an agreement, we're not a party to that agreement. Take no position.
The town's not agnostic to the existence of the 95 agreement. It did sign the agreement, so
I'm saying to whatever dispute is happening today
Got it.
about
Okay.
providing. So yes,
just be clear.
yes. Take no position on that. What Brian is saying he needs is he needs something from the city of South Portland saying that they are willing to accept sewer, whether it's in the form of a permit, like he would get from the Scarborough Sanitary District if he's doing, issuing a building permit or whatever it is.
Can I jump in on that?
Yes, yeah.
Sorry to interrupt again, but the condition doesn't say a permit specifically. It says a
Right.
new agreement.
Yeah.
Can you, I guess I'm struggling with, why does adequate sewage disposal necessarily equal a new agreement between SMF and?
That's a good question. Yeah, it's a good question. I think it was the way it was articulated when the city of South Portland notified the city, and again, you can see the language in the correspondence that's in your packet, is that the city said it would not provide service unless these two things occurred. So Brian's permit referenced those two things that needed to occur.
Okay, and the two things
But-
being a payment and a new agreement.
That's right. Now, to the extent that, I think, Brian, we could talk to the extent that the city instead, tomorrow said they have a permit and we're willing to issue it, I think that would satisfy Brian. It's not, you know what I mean? So what really needs to happen here is something from the city saying that they're going to accept the service. That's I think, in essence, what Brian was getting at there.
Yes.
Ms. Saucier, I have a question regarding the statement by State Manufactured Homes that the check which they provided to the city of South Portland was cashed. Does that de facto mean that they've accepted service?
I have no idea. I don't know what it means. I don't know if they accepted again, we're not a party to that agreement. You can ask the city of South Portland about whether they will provide service based on the cashing of that check. What the town of Scarborough needs to know is that there'll be sanitary service for these homes before he can issue a building permit. That's the whole case.
But it does throw a question in this.
Yeah, exactly. I have no idea if the city of South Portland accepted a check or didn't accept a check. We are not the city of South Portland.
What forms of acceptance can the town
Maybe have
accept?
Brian come up and
I mean, is it a phone call? Does it have to be a written thing? Just so I understand that a little bit better.
Well, I definitely want to have something in writing.
Yep.
And it doesn't have to be a new agreement. It could, again, I don't know their system. I don't know if they issue individual sanitary district permits for everything like Scarborough does. It could be a letter. It could be, I'd even accept an email if they wanted to get this thing cranking. I don't care. I just need to know that it's going to go where it's supposed to go.
But some
And
form of-
everybody's going to accept it.
And I appreciate that but it's a form of written communication.
A form of written communication,
yep.
confirmation, if you will.
Thank you. Any other questions, Michelle, Christine?
I had nothing else. So if you have any questions.
Yeah, I was gonna say, I was gonna turn it over to Mr. Laurie for your opportunity to cross-examine, so.
You might want to stay near the mic.
Yeah, actually, if that's a good point, if we can.
Take turns.
Yeah, please take turns because you should use the mic,
Another
please.
extra mic.
Does that one work? It looks distinctly unplugged in over there, so.
Okay. Mr. Longstaff, is there any problem with the 100?
Yeah,
Sorry, is there any problem with the disposal of the waste from the 112 existing homes in Pinecrest?
Not to my knowledge, I didn't issue permits for the 112.
Thank you. And this one would be handled exactly the same way, is that correct?
I can't speak to that because I didn't issue the permits for the 112.
But you know that this home is going to connect to the same system, do you not?
I've already testified to that.
That is not a response.
I think it is a response. I've already testified that I know the infrastructure is there. Is that satisfactory?
In your Kafkaesque way, yes, it is.
Actually, let me take a
Sorry.
quick stop here. The nature of cross-examination can sometimes be contentious, but this board will not accept personal attacks or aspersions drawn on other people's character. And
That is
goes for both-
character.
That goes for both sides. So I'll say that. But think about how you phrase those asides, Mr. Laurie, in the
Okay.
future.
Do you have any reason to believe that the 113th unit, which is what's septic disposal of 113th unit, will be any different from the 112 that are currently being served by the South Portland sewer system? Do you have any reason to believe that it will be any different?
Once I receive confirmation from South Portland, I don't believe it will be any different than the other units.
So we're only talking about getting some confirmation from South Portland that they get an agreement, they have an agreement that they like, which gets rid of the 1981 agreement. Is that what you're saying?
David's getting into what Brian may or may not want from the agreement. Again, we have no, as we've said, no role in the agreement. All Brian has, and I think he's testified to it 4 or 5 times at this point, needs some agreement, he needs something from the city of South Portland saying that they're going to accept the service.
Understood, Mr. Saucy.
The question we raised in this appeal, the principal question, not the only question we raised in this appeal, is whether Mr. Longstaff is being unreasonable at this point in not accepting that the condition has been met. And I still don't understand from him, and perhaps if South Portland chooses to testify, which they have not. And what we're hearing here is hearsay that they have said they will cut off the system. Are they going to cut off 112 units as well as
Mr. Laurie,
this
we're
unit?
giving you an opportunity to cross-examine, not to re-argue. I believe the question has been answered.
I do have a question, but not. Thank you. I do have a question for you and your clients, if we can go back to that, if you're done
Sure.
with Mr. Longstaff.
Well, I'm not done with
Yeah,
him,
I
but
think
go
we
ahead.
should probably complete
Okay.
his cross-examination, and then we'll go, yes. we'll have that-
Can we maybe move these along to more applicable questions for
that's
Mr.
what we're trying to-
Longstaff?
That's what we're trying to do, yes. So,
Is there any, to your knowledge, is there any way to separate the sewage that is coming out of the SMH system into the South Portland system to separate out the stuff coming from this unit, the 113th home from the other 112? Is there any way to separate the two?
I have no idea. We don't provide that service, so I don't know how it's set up.
So you're not claiming expertise in this area at all? That's correct?
I can't claim expertise on South Portland's system.
We're talking about the SMH system. Is there a way, you said you're the licensed plumbing inspector for Scarborough. Is there any way that the septic waste coming out of the SMH system can be separated between one unit or another unit, or 112 units or 113 units?
Mr. Laurie, I'm gonna halt that, and I'm not gonna make Brian answer that question. We're looking to Mr. Longstaff as our code enforcement officer, not as an expert witness in the installation of plumbing systems and sewage systems that are contracted with the city of South Portland.
Sorry,
If you have a plumbing expert to bring to the table, let us know. But Brian's not going to be the plumbing expert for this board.
But it is all one system. Do you agree?
I don't.
The SMH system is all one system.
I
Do you agree?
actually don't know, Mr. Laurie. I don't know what their system is. It was already in place before I arrived in Scarborough. I have had no opportunity to inspect their system. South Portland takes their sewage from their system. They have no way to control on state manufactured housing land or in Pinecrest land. It's just they're the repository. They're the repository of that sanitary waste.
Okay, let's go back to one other question. One last question. Why does the 1981 agreement not satisfy the condition that you put on South Portland, you put on my clients? Why does the 1981 agreement, which is now in the record, which was not known at the time, why does that not satisfy the condition that you imposed, that there be an agreement?
If the city of South Portland called me tomorrow or emailed me tomorrow and said the 1981 agreement is in effect and we're honoring it, then I'm good to go.
We have nothing else.
Gotcha. Any other questions at this time for these folks? Thank you very much. Then, are there, would the city of South Portland or like to present or speak at this time?
Good evening. I'm Sally Daggett. I'm one of the city's attorneys, but not in the litigation. So to the extent you want to grill me about issues in the litigation, I am not going to respond to them. Sorry, 'cause I'm not the city's counsel in that matter. The city of South Portland's position has been made known to state manufactured homes for quite some time, and they sort of waited till things really came to a head before trying to at least talk to the city about what was what. But as I think Mr. Saucier pointed out, the city of South Portland has been in touch with representatives of state manufactured homes for several years now about the need to update the sewer user agreement between the city, because quite frankly, there is currently no agreement between the city of South Portland and state manufactured homes. The 1981 agreement is with Pinecrest Mobile Home Court, Inc. And
Sir,
the agreement it's got, there have been numerous entity changes that own different parcels that comprise the Pinecrest site. And while there is language in the 1981 agreement that talks about Pinecrest being able to assign the agreement, there's no evidence of that. The agreement from 1981 has a number of issues with it, doesn't identify correctly all the parcels that are served by the city. So the entities have changed, the parties, the parcels have not been clearly identified. The 1981 agreement doesn't also say expressly, even though it was a requirement of the city's ordinance since 1975, that there be a sewer connection fee. And this is a different fee than the sewer user charges that all of you who are served by public sewer, most likely that, the Scarborough Sanitary District charges a sewer user fee. The same thing is true in South Portland. There's a sewer user fee for anybody who puts wastewater into the public system. But there's also separately in South Portland a sewer connection fee, which means anytime, and actually I can show you where this is in the ordinance. If you turn, hopefully you still have the handout that got submitted to you from the last hearing, but there is an exhibit there. It is Exhibit A, if you have it handy, but I can read it to you, which is a copy of Article 4 of the city's Code of Ordinances of Chapter 22, which is the ordinance that relates to sewers. And in Section 22-17, which is on page 8 of the city's submittal to the Board of Appeals back in January. In 22-17A, there's a provision that says that applications for permits to connect with any public sewer or drain, and then this is also key, and I think it's a point that's been maybe overlooked by many folks in the room, is that if somebody wants to connect with any private sewer or drain, which itself is connected to the public sewer, then a connection fee is required. In addition, in the next paragraph, in section 22-17, you can see also that a connection permit shall also be necessary for any change or expansion of use which will increase the amount of gallonage of wastewater. And so you heard the colloquy back and forth when Mr. Longstaff was being cross-examined by Mr. Laurie about what's the difference between the 112th and the 113th unit. The difference is that there is more wastewater being ultimately put into the city of South Portland system. And so that for the additional, whether it's 1 unit or 31 units, that those additional units require a connection permit. And this has been an issue for state manufactured homes for almost 2 years now. They have been refusing to pay a connection fee. And the 1981 agreement doesn't expressly require that, but the ordinance did at the time. And I think nobody really was focused on this issue back in 1981. I wasn't present for it, but this is, again, my thought. But the 1975 ordinance did require a sewer connection fee. But at the time, in 1981, the fee was $15. Okay. Since then, the ordinance has been amended, and we'll show you where that is. So same handout from the January meeting in Exhibit A. If you look at section, it's on page 19, where it starts. There is a sewer rehabilitation fund, and this is something that is new since 1981, that the city has set up a sewer rehabilitation fund, and it is funded by sewer connection fees. So you can see on page 19 in section 22-160, and subsection D, E, and F, that these sewer connection fees are being put into the separate fund to basically fund future capital needs of South Portland's wastewater treatment facilities. Then if you keep going on to page 20 of the ordinance or the handout, which is an excerpt from the city's ordinance. In section 22-164, and this is again a change from 1975, it's now that the city council by order adopts the sewer connection fee. And the fees are substantially higher than they were in 1981. In 1981, the connection fee for a single unit was, again, $15. In today's world, it's based on the amount of wastewater to be submitted to the city system. And so for these 31 units, the sewer connection fee is roughly $35,000. So that was something that State Manufactured Homes did not want to agree to, and that was something that was important to the city to have in the agreement. Not only that the agreement be with appropriate parties and be with cover the right properties, but also to have this requirement about the sewer connection fee. It is required by ordinance, and the city is thinks that the 1981 agreement needs to be updated to reflect today's reality. And the reality is that the entities have changed, the parcels need to be updated, and the current sewer user agreement with State Manufactured Homes, Inc. needs to address the changes in law that have occurred. The 1981 agreement does provide for the fact that there will be changes in law. If you look, and this is, yes, in the applicant's submittal to the board. And if you look at the administrative appeal filing from December 6th, let me just find it here. Got multiple copies of the joint sewer agreement, but I thought it was in here. Maybe it's not. But regardless, the 1981 agreement says in section 1 that it's subject to changes in law. And I think pretty much any contract for when there's something that is dynamic, such as a local ordinance, I don't think that it's realistic to think that the law is not going to change and that everything is frozen in time. But regardless, the city of South Portland today does not have an assigned sewer user agreement that covers the 31 units that it is acceptable to the city of South Portland. And as you can see from my letter to Attorney Beagle from November 11th of 2022, at which time the State Manufactured Homes had tendered a check to the city of South Portland finally, after sort of over a year of back and forth between State Manufactured Homes and the city about the sewer connection fees. Ultimately, State Manufactured Homes did submit a check, was paid under protest for the sewer user fees. And but at that time, State Manufactured Homes, and even to date, has not submitted a sewer user agreement that's acceptable to the city of South Portland. By my letter dated November 11th, 2022, I indicated that what the city's position is, and attached a copy of the sewer user agreement that updated it, because an earlier version had left the number of units blank. But the November 2022 version that got sent to State Manufactured Homes representative made it clear that it was the 31 units. And it addressed the issue about the sewer connection fee, and it updated the entity, updated the parcels. And there's a practical reality here. I know that State Manufactured Homes thinks that they got an agreement for 200 units. That's not what the 1981 agreement is, but I'm not here tonight to debate with you what the 1981 agreement, because I don't think that that's for you all to decide. But I will say that for these 31 units that State Manufactured Homes wants to, they want this additional wastewater and to flow to South Portland, they need the approval from the city of South Portland for that to happen. And the other point is that State Manufactured Homes makes the argument that that these 31 units are not new connections, and that is incorrect. As I indicated when I was referencing the current version of the city's sewer ordinance on page 8, it is considered to be a connection when there is a private sewer or drain that itself connects to the public system. That is a connection. So all 31 of those units are new connections into the city of South Portland system. Even though they may go from first to a private pump station, but ultimately the flow goes into the city system. And so those are new connections. I do want to just talk a little bit about the law, because I concur with the code enforcement officer's attorney that the pursuant to the administrative appeal that got filed by State Manufactured Homes, they're only appealing the code enforcement officer's alleged refusal to issue certificates of occupancy. They do not, on the face of their administrative appeal, challenge the conditions of approval that got attached to the building permits. And there has been no timely appeal of that issue to the Board of Appeals. I think your ordinance in section, I guess it's section 5 about the Board of Appeals in subsection C makes it clear that any appeal of any decision of the code enforcement officer has to be commenced within 30 days of the date of notice of the decision, and then the appeal has to explicitly set forth the grounds for appeal. So the grounds for appeal contained in the administrative appeal in front of the board tonight only relate to challenging the alleged failure of the code enforcement officer to issue certificates of occupancy. And there's case law that says that basically if somebody misses an appeal deadline and it's a decision that is then subject to the Rule 80B process, that's a rule of civil procedure in court, and any appeal that, from a decision that either has to go to the Board of Appeals and then off to court, if that's not timely done, the case law is that there can't be a collateral attack on that decision if somebody didn't timely appeal the initial decision. And that's what I think is what's happening here, is that there wasn't a timely appeal of the building permit conditions through an administrative appeal to the Board of Appeals, but through this administrative appeal that got filed in December challenging the alleged refusal to issue the certificates of occupancy, State Manufactured Home is now trying to piggyback onto, oh, well, this is also our challenge to the building permit conditions that were attached, for the conditions of approval that were attached to the building permit permits that were issued in November. But they didn't timely appeal those, and so we don't think that the board has jurisdiction over that argument. I think the issue before the board is solely whether the code enforcement officer has properly declined to issue the certificates of occupancy. So that is the city of South Portland's position. Again, I'm not here to debate the underlying legal issues about interpretations of the 1981 agreement or the 1995 agreement. It's just simply that the city's position is that it doesn't have an acceptable sewer user agreement with State Manufactured Homes for the property that the city is being asked to serve, these 31 additional units. And so it's appropriate for the code enforcement officer to have declined to issue certificates of occupancy because South Portland has not signed off on the acceptance of the waste at this time. So.
Thank you, Ms. Daggett. Before I let Mr. Laurie have a chance to ask any questions he might have, any questions from Mr. Bork?
Yes, Ms. Daggett. My first question is regarding the check that was presented to the city of South Portland. Um, Did the city of South Portland cash that check, and if so, what account is it in right now?
I'm sorry, I didn't hear the last part of the question.
The check that was presented to the city of Portland by State Manufactured Homes for the sewer connection fee, okay, which really goes into a fund to upgrade sewers.
The sewer rehab fund,
Yeah,
correct.
exactly. Was that cashed by the city of South Portland? And if so, what account is that in right now?
I don't know about the account, but I say yes, the city cashed the check, but tomorrow the city will be issuing a refund check. The city accepted the check, thinking that it would work something out with State Manufactured Homes, but given the events that have transpired since the date that that check was tendered, again, it was tendered under protest, the city has made the decision that it's going to refund the check. There is no, the city accepted the check on the thought that there would soon be an acceptable sewer usement agreement signed by both parties. There is not, it's been, 2 months now, so the city is refunding the check.
Thank you.
Michelle, did you?
Do you require all new connections to have a user agreement, or is this unique to state manufactured homes?
The ordinance requires an agreement and the form of the agreement may vary, but yes, the city does require an agreement. And obviously this is it's not unique that the city has provided sewer service to properties that are outside of the city limits, quite frankly, but it's rare, but not, I'd say, unique. The city also has several agreements with the town of Cape Elizabeth, or property owners in Cape Elizabeth, and maybe even the town itself. There are some portions of Cape Elizabeth where the city accepts their waste. So
Okay.
I have a question as well. So is a user agreement a prerequisite to a connection permit?
yes.
Okay. Where is the user agreement in the ordinance? I'm trying to,
The requirement of a user agreement
yeah.
on page 8 of the city's submittal to the board, where it says it's section 2217 subsection C. Each application must include an agreement on the part of the owner to abide by all the provisions of the chapter and all the rules and regulations.
Thank you.
Sorry, one second, Mr. Borg.
Just one additional question. Oh, gosh, it escaped my mind. I'm sorry, I lost it, so. I apologize.
We can come back.
All right, yeah, we'll give you a chance to.
He's going to ask me questions because I'm not a witness. So I am not a witness. Thank you. I am a representative of the city. I am not a witness.
But she also said she wasn't making a legal argument, finally concerned. So I'll defer to you on this one, Doran.
I don't think he should be cross-examining her, but he can make a further statement.
Yeah, we're definitely going to let him make a further statement. That's true, but
But I think she was just making a legal argument.
I would-
Justifying.
I would like to point out that she did not address the applicability section, the scope of the whole sewer stuff that she's relying upon, all those sewer ordinances, the entire chapter 22 is limited by the scope. If you look at Article 2, Section 22-2, it says that it does not apply outside the city, to buildings outside the city.
Ms. Moore, I'm going to stop you right there, and not let you make the argument. I feel free to do that. But I think on the advice of Mr. Parkson, we're going to move to your opportunity to make a final statement. And that can very much include the argument you're making right now, but we'd like to move to that stage.
Well, I would suggest that unless she explains that, you should strike all of her testimony about the South Portland ordinances.
I don't think you have to strike it. You can decide you can decide the evidence, the.
Well, it goes to
put-
weight,
You put
right?
the weight, the weight that you care to assign to it, exactly. Thank you for-
Mr. Laurie, can I ask, maybe this will come at the end of your final statement. But so your point about the scope of the South Portland ordinances, there have to be some rules, though, that govern how SMH connects to the South Portland system.
Well, they have to provide acceptable waste, that's for sure. And that's actually what that reference to the rules of, acceptable waste is governed by the Clean Waters Act, basically. South Portland got grants about the time that they enacted Chapter 22 for the building of a treatment plant and for acceptance of different classes of waste and non-discrimination. This is actually a discriminatory charge because there is no connection. There is no connection to be charged for. The connection is to the SMH system, the existing 112 home SMH system. It's now going to be 113. The waste will come out exactly the same way. And there's no reason for this other than South Portland wanting to collect a fee for something which it doesn't go into it isn't subject to any of those ordinances, as I said before, because of section 22-2.
There have to be some rules governing.
There
how-
are. There are. They're the rules for the acceptable waste. That's what they are. It's not the section she's pointed arrows to. Those are not the rules that are referred to as changing over time. It's the waste has to be acceptable to the system. That was the understanding in 1981. We're not changing the 1981 agreement. They are.
So is it your position that the
This is Ralph.
1981 agreement replaces, it imposes, it stands in the place of the city of South Portland ordinances?
Well, I'm saying that the South Portland ordinances don't apply. They're a red herring. They do not apply by their terms. And it's pretty clear if you read they repealed the entire chapter and left sections 1 and 2, articles 1 and 2. They repealed the whole rest of it and replaced it. That's, if you look at I've been in communications with the South Portland clerk
Could I,
as to the history of this.
one of the board members want to make
Mr.
a-
Chairman, I
Yes,
don't
yes.
believe this is in our purview, this discussion.
I'm inclined to agree with you, Ms. Snow. And it's not that, Mr. Loya, you don't have the right to make a statement on it or things like that, but I tend to agree with Ms. Snow on this one, that this is taking us beyond the realm of the administrative appeal that we have before us, and that we're starting to touch into matters that were probably best left to the courts.
One other thing, I'd like to make an offer of proof with regard to what Sally Daggett said. Alan Beagle is here tonight. If you want to get into the issue of whether SMH is the same entity that signed the agreement, he's here to testify to. I'm just saying, if you want that.
Appreciate the offer, but I think that takes us rather far afield. So, but Mr. Loy, you have an opportunity to make a final statement at this point, or if you feel that we were ready to go, I'll open up to the board for final questions. Yes, we have. We've gone through that. Sure. Actually, it's 9 o'clock. If I might suggest we take a 3-minute break just so the board can use the restroom and whatnot. I agree. And so we'll come back to you in 5 minutes. If that's okay, Ms. Flory? Thank you. And Mr. Loy, we'll give you a chance to make some final concluding remarks, and then we'll proceed from there.
I referred earlier to Mr. Longstaff's statements as being Kafkaesque. Those of you who have ever read anything by Kafka or about Kafka, you'll know that it takes you around and around in a circle. The argument takes you around and around in a circle. He doesn't know what he doesn't know, what he doesn't know, but it does know it. He does know that they've got adequate sewage, which is adequate septic disposal, which is what the ordinance requires. He knew that when he posed the condition. He knew that now. He knows that now, and you know it too. And it isn't a question for you of whether you're bound to your prior decision or not. And that's applied sparingly, no doubt about that rule. However, in this case, nothing has changed. The ordinances have not changed, and everybody knew at the time that they had adequate sewage, septic disposal. My God, they've got 112 units there pumping out raw sewage to go to South Portland into the treatment plant. This unit, I should say, because there's only one really that's technically before the board. This unit is, in fact, going to be just adding to the stream, and they pay for volume in the stream. This is a hidden charge that is unauthorized. The 1981 agreement contains an integration clause. It's supposed to be a complete statement of the deal. And there was nothing in there about connection charges. There's no connection here too. It makes no sense. The whole thing, as I said before, is Kafkaesque. And if we have to go to court to have the court say that Scarborough is wrong, that's what we're going to do. And it is Scarborough. Scarborough is carrying the water for South Portland. Scarborough is the one that's going to be responsible for this part of it. South Portland will be responsible for breach of contract, for which they don't have immunity. You at least have immunity, your town at least has immunity. But you're here to do the right thing under the ordinances. Everybody knows that they should have their permits, and it's up to you to grant them. Thank you.
Thank you. Any final questions from the board for Mr. Laurie or for any of the other witnesses? Ms. Bork?
Yes, Mr. Laurie keeps referring to this as a connection charge. Now, if I'm not mistaken, it's really an upgrade fund, which in fact is payable after 10 years with interest.
That's the South Portland ordinance. If Mr. Langstaff can profess ignorance of all this stuff, can I? Because I have ignorance of it. Absolutely. I have no idea what they were going to do with the money. They say they're refunding it. All I know is they demanded 31 payments up front. You know, normally when you build a house and you get your building permit and you get your certificate, before you get your certificate of occupancy, you pay all the fees for that unit. You don't pay, well, I don't know what the practice is in South Portland. I shouldn't say that because they may very well rip people off up front for all of the fees, even though they're only building phase one. And this is essentially phase one. They could only get 8 units because of COVID. And you know, this is all about 1 unit out of 8 out of 31, but they demanded fees for all 31 up front. And that's the extent of the fee thing. Perhaps that's why they're refunding it. I don't know. But
You're misunderstanding my comment, my question.
I'm sorry.
What I'm saying is that it's not really a connection charge. It goes into a fund to upgrade the source system as needed in the future. And it's very clearly stated in their document, which has been provided to us, that if they haven't spent that money, you know, within 10 years, it's then refunded with interest. So this is not a sewer connection fee.
Well,
Just wanted to
they
make that
labeled
point.
it one. They labeled it a sewer connection fee. And they asked, I guess I don't understand the question.
I'm just basing it on the evidence that's been provided.
I disagree. Do
Any
you
other
have
questions?
anything else for me?
Nothing for me. Thank you, Mr. Laurie. Appreciate it. Sorry about that. Okay, with that, normally in a variance appeal, we did offer a chance for neighbor and public comment, but the nature of an administrative appeal is such that I don't think that's appropriate. So with that, I will close the hearing for the offering of evidence and the appeal, and invite the board to discuss the issue. I think we have really a couple things to kind of lay out. The first are the findings of fact that we will make as part of this. I will say that we should not feel like we're going to bind I don't propose that we bind ourselves with a vote tonight. I think it would be more appropriate for us to discuss what we've heard, establish findings, what we believe the findings of fact to be, and then ask Mr. Parkinson to write up those findings and write up an appropriate document that we can then discuss as a formal document and vote on formally next meeting. And I know that delays something for the appellants, and for the code enforcement officer, but I think that establishes the best paper trail for us as this case goes to court for others, and also gives us a chance to reflect on the wording and the nature of the wording that we'll have to put together for final decision. So if I'll offer that as a suggestion, and from a process perspective, does that make sense to the board?
I was just wondering, Mr. Chair, what our council thinks about that. Do you feel like it's inappropriate to make a judgment tonight, or?
Yeah, so my recommendation is that you begin your deliberations tonight and go as long as you feel comfortable going, and you might want to discuss that. Is there a time that you want to stop and not go beyond without agreement? That's certainly something you can do. And so we can get a feel of what your thinking is. And there may be a consensus, there may not be a consensus. We'll just have to see. And then allow me to write up what I'm hearing in the form of a draft decision without the vote part in it, without the decision, and that you make the actual vote at the next meeting. In Maine, a lot of boards you see will close the public hearing and then go straight to a vote. In other words, the chairman says, what's the pleasure of the board? Well, I think they met their burden of proof. I don't think they met their burden of proof. Is there a motion? Discussion, they discuss it a little bit, then they vote. They haven't adapted any findings, and the ordinance is clear, state law is clear. You need to adopt detailed findings to support your decision. So that's what I'm recommending. You do that first, then take the vote, as opposed to taking the vote and backing into your reasoning, kind of after the fact reasoning after you've already voted.
Okay. My follow-up question is, if we do come to some agreement where we feel like we can vote tonight, can we do that? Like, do we have to make that decision right now?
No, it might,
Whether we're
my
going to vote on
recommendation
it
is
or
that
not.
you see the findings in writing. You could have a consensus, you could almost like have a straw poll type of thing, but not a binding vote until you actually see the written word.
What we normally do on regular appeals
Mhm.
is we will come to a conclusion and state facts. So there's an actual vote at that point, but we wait until the following meeting to actually formalize the written findings of facts. So this is very similar to what you're proposing, is very similar to what we already do.
So all but the actual vote is what the
Yeah.
only modification I would
So-
say.
Right.
And I think what I would propose is, and I think Michelle made a good sort of leading comment. If we come at the basis of a conversation and say no later than 10:15, it'll give us an hour to have a robust discussion on this. At the end of that, or even before that period, if it's clear that we're all in rough alignment, then I think we'll know and we'll be able to sense that. We can end the conversation at that point, and then again leave it to Durwood to summarize in a format that will be appropriate for the next people who will take a look at it, and then we'll vote on that formally next meeting. But I think we'll probably know one way or the other, or we won't, and we'll have to decide at the next meeting based on the findings that we have put together where to proceed. So.
And I just want to emphasize, because I saw like a case come down that discussed this. when I'm doing this, it's just for discussion purposes. I'm not, deciding anything. You're the deciders.
Right.
It's just an aid for your discussion.
With that, I'd like to kind of run down the list here. So I'd let me start with Christine, and would like to just put your thoughts out, and start us off, I guess, Christine, and then we'll take it from there.
Okay, I'll try to do that. Well, the building permit, which was issued November 7th, had a sewer condition attached to it. The city of South Portland has updated their rules and laws, and they need development to, comply with their new laws and rules. There was no appeal of the building permit with the condition. And I'm just having difficulty understanding. I mean, Mr. Longstaff, I believe, is doing what he's required to do by law. And I certainly support that. And I think to me, it's pretty clear cut. And I'm sorry that you're in so much difficulty, but I'm sorry that you couldn't look at it another way.
Go ahead, Michelle.
I tend to agree with Ms. Snow. I think that Mr. Longstaff has laid out his thought process in his non-issuance of the permit, and it sounds like there's a lot between South Portland and the appellant to work out before that this could be issued. I don't see where any laws were broken on Mr. Longstaff's end, and I don't know what you need to do to try to rectify this agreement with South Portland, but I tend to, I guess I don't have to say which way I lean, but you can probably guess from my statement.
Dave?
Okay. So what we're here for right now is to determine whether or not Mr. Longstaff followed the law and, perform his job according to the requirements of the town of Scarborough, excuse me. I was going to say South Portland, which is a city, but anyway, that's it. But this is a little complicated because really what the issue is nothing at all regarding did he do his job at all. It's really a dispute between the appellant and the city of South Portland. And I don't see how we can possibly get involved with that at all. In particular, I'm concerned because I don't see any evidence at all that the city of South Portland provided any kind of a form, to the applicant regarding what they wanted, in this agreement. I did see evidence that the State Manufactured Homes Organization did provide a form which they devised and signed and presented to the city of South Portland with a check, which, the city then cashed. And now they're claiming they're going to refund it, which is kind of odd. This is not anything that we should be involved with at all. What's going on between State Manufactured Homes and the city of South Portland. They have to work this out on their own. Now I realize that there's a lawsuit going on also. We have to ignore that. That's not our business whatsoever. This is very narrow. Did Brian Longstaff do his job or not? That's it. And from what I can see, he did.
Thank you, David. Kyle?
Durward, let me ask a question of you first.
Sure.
What's the standard of review we apply to the refusal to issue a certificate of occupancy?
I think it's a de novo appeal, so there's no deference to the decision-making of the code enforcement officer. You're entitled to take in all of the facts that you heard on the record and make a decision applying those facts to the ordinance provisions. When I say ordinance, I mean Scarborough ordinances, but it's not a deferential review.
Okay. I don't think there was any improper action in failing to issue the certificate of occupancy.
Okay. Got it.
Yeah.
Very concise. In fact, so concise, I was still trying to figure out what I was going to say next, and I have to spit it out. But no, it's fine. Thank you very much. And actually, concision is always appreciated at 9:20 p.m. Again, I think my other board members have summarized it well in saying that the issue here is, did Brian act inappropriately or illegally in withholding the certificate of occupancy? He did not do so capriciously. He did not do so arbitrarily. He did so on the basis of a contingency which had been agreed to by the property owner and had not yet been fulfilled. On that basis, it strikes me that it would have been arbitrary or capricious to have granted the certificate of occupancy with the outstanding condition still not being met by the owner. So I'm using more words than Kyle, but I feel very much the same way.
Let me just add briefly. I mean, I think the question, I think the town asked us to address the issue of whether the appeal was just from the condition itself, as well as the refusal to issue the certificate of occupancy. I think, looking at the appeal, I think the appeal was only of the refusal to issue the certificate of occupancy, but I don't think it matters, because I think that the condition imposed was the condition imposed was basically designed to ensure adequate sewage disposal, and it equated a new sewer user agreement with ensuring adequate sewage disposal. I think that's reasonable. I think that meets any standard of review that we impose. And I think that, so I think that even if we were to consider the appeal to be from the issuing of the condition itself, I still think that we would deny the appeal.
Now, I think my point on that is, I think if it had been I agree first off that the appeal is of the refusal to issue the CO. Had there been a dispute about the condition, there was a 30-day window during which that could have been disputed and brought to our attention, and it was not. And I'll remind everyone that last month we decided that we did have standing to hear this case because it attached to the denial. And that denial, the appellant promptly within the 30-day window filed their administrative appeal, and thus the timing went forward. If they're trying to bring this in and say, if they were trying to say, no, actually what we meant to do was appeal the original condition that was attached because we don't feel it was valid, I think we'd have a very different conversation. It would have been, no, you don't have standing. Sorry, you missed the window. Too bad, so sad. So that's kind of where I come out on that one. But otherwise, Kyle, I don't disagree with you at all from what you're saying.
Yeah. So I think that we might want to include in our findings something about just, well, maybe this would be in our conclusions of law, exactly what it is, the decision that we're appealing from. Because I think that the town is right that needs to be clarified.
Yeah.
Gotcha.
Are there any other items? We were presented with a lot of factual evidence and a lot of testimony. Is there anything else that we wish to highlight in our decision-making process at this point, or?
I would just like to say I appreciate all the facts that were presented today. However, we're not in the position to hear. We're just trying to decide if Mr. Longstaff was adequate in not issuing this permit. So there was a lot of information that's just simply not relevant to that particular appeal. And I hope that you guys can work this out in whatever a forum that is appropriate in the future.
One fact I think we can find, and I think this is undisputed, but I think is important, is that there is no recently issued, there's no recently enacted user agreement between SMF and the city of South Portland. That was the condition in the permit. And
There's no new, I think that's the word new.
yes, yeah.
I mean, most people wouldn't say 1981 is new.
Right.
I suppose the history of the universe is new, but.
The other thing I'd say is, and I would argue, including this as fact as well, is that the 1981 agreement, on its face, gives the city the ability to treat the what was at the time the Pinecrest Mobile Home Court Inc. as effectively just another customer of the South Portland system. I'm not sure what they call themselves. There's the Water Resource Department, but I'm not sure what they call themselves back then. There's nothing here that sort of implies that they have special rights that would pull them out and make them a preferential customer of South Portland, and essentially that's what they're asking to have to be treated as under this. So
I would suggest though that we should be careful not to make any finding about whether the 1981 agreement is in place or whether it applies, because I have no idea.
I
And I
agree.
don't think we had an adequate record.
No, and I agree with that. It's more, it has been relied upon differently by different folks at different times in the course of both last month's and this month's discussion. So we accept that it is a document that exists. I think we leave it to the more competent courts to determine whether it's enforceable in its current form or whether it's not. But at least from my perspective, it's difficult to see this agreement as again providing preferential treatment to Pinecrest at the time, now SMH, versus just simply being another user agreement that would apply to other folks in the South Portland system.
Mr. Chair, it might be also important to include the letter from the city of South Portland to the town of Scarborough stating that there was no agreement and therefore there would be no service.
And I think that's an important one, David. I agree with that as something to include, Durwood, because again, in terms of what we can rely upon or what we can reasonably expect a code enforcement officer to rely upon, I think official communication from a contracting party is something that we would have to take into account.
Okay, got it.
With that, I think we have a sense of where we stand on this issue. But I think seeing the language that Durwood you'll provide to us and putting it in the legal form that we're not, as a volunteer board, normally able to construct on our own will be helpful. So with that, I would entertain a motion to defer a final vote until next month.
Can we say what the date of the next meeting
Oh,
is? 'Cause I need to,
To March 8th, the regularly scheduled meeting on March 8th next month.
oh, well, just, if you don't mind, just 1 second here.
Oh, gotcha.
I'm almost there. March 8th. I unfortunately will be out of the office and out of town, and those plans can't be changed otherwise. So
Okay.
I'll have large problems. I could supply the decision to you in advance, and then you can handle it.
Yes,
Yeah,
I think
you
that
don't
would be
need
fine.
me to, and then
She might not be here either, so does that affect her?
we'll still have 4.
Yeah,
Yeah.
4 is a quorum. We should be okay.
Right?
Okay.
Oh, so I may have mentioned this before. I'll get this to you well in advance of March 8th.
Yes.
But don't send emails back and forth between each other about the draft, all decision, all discussion that needs to be in the open
Exactly.
session.
I'll remind everyone of the Freedom of Access Act issues around that. So while we might be tempted to send an email, please no reply alls, no replies. Consume it, read it. It's advice and it's coming from our council, so that's okay. But we should not discuss it outside of a public forum where others have the opportunity to hear the deliberations.
Should this be part of our packet for the March meeting? Wouldn't that be?
Yeah,
Probably.
I think we can
Oh,
give
yeah.
it, we can give the draft to the,
Mhm.
all,
So-
you know, in the package so
you
people
could-
can
so
see it.
Just coordinate that with Darlene.
Hopefully we'll, and actually, George, hopefully you can get that to us
Yeah.
ahead of that. And then, because the packet could come out a little bit later, and we don't know the full document for next month.
The package probably comes out a week ahead or
Yeah,
like
2 weeks.
Friday. 2 weeks,
Typically.
2 weeks?
Yeah.
If we're lucky.
Yeah, check with Darlene. She can help you with that.
All right.
Okay, so I'll again entertain a motion to defer this to the March 8th meeting for final vote. Do I have a motion?
So moved.
Thank you, David. Second? Second from Ms. Snow. All those in favor? Motion passes unanimously. And that's it for that item. We have comments from board. We're tired, I think is the comment that I'm hearing most loudly there. Then the only thing we have left on the agenda is a motion to adjourn.
So moved.
So moved.
Second.
Seconded. All those in favor? Aye. The meeting's adjourned.